In this video, I am going to discuss most important questions on Law of Contract 2. Friends, this question have been taken from previous university questions which are very important from my point of view, and on the basis of these questions I have given the answers in a very compact form so that you can memorize this whenever you are going to give your examination. I hope this video will be very helpful regarding questions on law of contract 2. So let us start. Question number 1. What do you understand by contract of indemnity? What are its essentials and how it differs from contract of guarantee? Discuss. This is the full question of 18 marks or 20 marks. Now you have to write all the parts in a compact form, and here I am discussing. Now, what is contract of indemnity? A contract of indemnity is a legal agreement. It is a legal agreement where one party called indemnifier, हिंदी में क्या कहते हैं इसको, क्षतिपूर्त करता, जब भी कोई लॉस होगा तो वो क्षति उसकी पूर्ति करेगा. Indemnifier promises to save the indemnity holder. क्षतिपूर्ति धारक यानी किसको करेगा? एक दूसरे पर्सन को जो कि इंडेमनिटी होल्डर है, फ्रॉम लॉसेस कॉज्ड बाय द कंडक्ट ऑफ द प्रॉमिसर हिमसेल्फ और अनदर पर्सन. मान लो किसी कारणवश उसको लॉस हो रहा है किसी कॉन्ट्रैक्ट में, तो contract of indemnity is a legal provision, legal agreement when one party promises to save other party from losses caused by the conduct of the promisor or himself or another person. It is essentially a promise to compensate for financial damage aimed at protecting a party against future losses. किसी भी पार्टी को फ्यूचर लॉस से बचाने के लिए a contract of indemnity is done. Now, what are the essential conditions of contract of indemnity? Two parties. It involves only two parties. The indemnifier promisor and the indemnity holder promisee. Protection against loss. Its primary objective is to save the indemnity holder from losses. अगर इंडेमनिटी होल्डर को लॉस हो रहा है, पहले जिसका कॉन्ट्रैक्ट है, अगर उसको लॉस हो रहा है किसी वजह से, तो जो इंडेमनिफायर है प्रॉमिसर है वो उसको प्रोटेक्ट करता है. प्रोटेक्शन अगेंस्ट लॉस. कॉज ऑफ लॉस. द लॉस मस्ट बी कॉज बाय द कंडक्ट ऑफ द प्रॉमिसर और एनी अदर पर्सन. द लॉस मस्ट बी कॉज बाय द कंडक्ट ऑफ द प्रॉमिसर. कोई गलती प्रॉमिसर से हो जाती है तो वो कॉन्ट्रैक्ट बनेगा और प्रॉमिसर को भरपाई करनी पड़ेगी. और एनी अदर पर्सन, बट नॉट बाय नेचुरल डिजास्टर्स और एक्सीडेंट्स. नॉट बाय नेचुरल डिजास्टर. डिजास्टर अगर हो जा रहा है या कोई एक्सीडेंट हो जाता है तो उस केस में नहीं, लेकिन अगर ऐसे लॉस होता है कॉन्ट्रैक्ट में किसी प्रकार का, तो जो प्रॉमिसर है वो भरपाई करेगा. फोर्थ इज वैलिड कॉन्ट्रैक्ट एलिमेंट्स. इट मस्ट कंटेन ऑल एसेंशियल एलिमेंट्स ऑफ ए वैलिड कॉन्ट्रैक्ट. इट मस्ट कंटेन ऑल एलिमेंट्स ऑफ ए वैलिड कॉन्ट्रैक्ट. जैसे हम कॉन्ट्रैक्ट लॉ में एक कॉन्ट्रैक्ट बनाते हैं, एक एग्रीमेंट करते हैं, तो उसमें क्या होता है? फ्री कंसेंट होता है, लीगल कंसिडरेशन होता है, and those who are taking part in the contract must have the capacity to contract. So these are the valid contract elements. It must be essential. It must be needed in this case also, in case of contract of indemnity. And fifth is express or implied. The promise can be expressed, written or verbal, or implied, inferred from circumstances. So these are the 5 essentials of a valid contract of indemnity. Now comes what is the difference between indemnity and guarantee. Guarantee हिंदी में प्रत्याभूति कहते हैं. According to the Indian Contract Act 1872, the key distinction lies in the number of parties, liability and purpose. Indemnity involves 2 parties with primary liability to compensate for loss based on a single contract. सिंगल कॉन्ट्रैक्ट के लिए कम जो भी लॉस कहीं होता है तो उसकी लायबिलिटी होती है बिटवीन द 2 पार्टीज. कन्वर्सली ए गारंटी इन्वॉल्व 3 पार्टीज. इसमें 3 पार्टियां होती है. कौन कौन? क्रेडिटर, डेब्टर एंड surety. These are 3 parts: creditor, debtor and surety, and serves as a security for a debt. The guarantee serves as security for a debt, while a promisor acts independently. Promisor क्या करता है? Acts independently, while a surety acts upon request. Surety कब मदद करेगा? On request. Furthermore, a surety has the right to sue the principal debtor directly. Furthermore, a surety has the right to sue the principal debtor, जिसने पैसा दिया है उसके directly, unlike an promisor. वो डायरेक्टली जो श्योरिटी उसको डिमांड कर सकता है. किसको? प्रिंसिपल डेब्टर को. सो दिस इज द डिफरेंस बिटवीन इंडेमनिटी एंड गारंटी. नाउ कमिंग टू क्वेश्चन नंबर 2, व्हाट आर गवर्नमेंट कॉन्ट्रैक्ट्स? Whether a writ can be sued against government for the enforcement of contractual obligation? Discuss. So government acts in India are agreements involving the state, central / state government, governed by Indian Contract Act 1872, but strictly bound by Article 299 of the Constitution. It means whatever the provisions given under Article 299, these contracts must obey. Unlike ordinary contract, government contracts must meet strict constitutional requirements to be binding. They must be expressed to be made by the President or Governor. They must be expressed to be made by President or Governor. They are made on behalf of President or Governor. They must be executed on their behalf by an authorized person. Second, the important point is they must be executed by some authorized person on behalf of President or Governor. They must be in writing. Third condition is they must be in writing. Implied contracts are generally not binding. Implied contracts are generally not binding. So they must be in writing. Written agreement होना चाहिए. Liability: the President or Governor is not personally liable, but the state is responsible, and the contract is enforceable against the government if all formalities are met. Now, writ against government for contracts. Whether a writ can be issued against government for the enforcement of contractual obligation? The answer: writ against government for contract. The enforcement of contractual obligation via writ, Article 226 and 32 is limited. In following cases, a writ is maintainable. These are the cases in which it is maintainable. If the government's action is arbitrary, unreasonable or discriminatory, violating Article 14 of the Constitution at the tender selection stage or during contract performance. If the government action is arbitrary, unreasonable, then a writ is maintainable. A writ can be issued. Public policy: if the government acts in a non-transparent manner, a writ can be issued. And third is, if the contract involves a statutory duty rather than just contractual rights. if the contract involves a statutory duty rather than just contractual right. In that case also, a writ can be issued. So this is the answer of the question, this question. Now coming to question number 3. Goods can be placed by the owner only except in certain circumstances. Goods can be placed by the owner only except in certain circumstances. Discuss. State the cases in which the goods can be placed by non-owners. The answer will be, under the Indian Contract Act 1872, a pledge is a specialized type of bailment where goods are delivered as security for a loan. Where goods are delivered as security for a loan or performance of a promise. Generally, only the owner or an authorized agent can validly place goods, often summarized by the principle, no one can give what they do not possess. Nemo dat quod non habet. Now rule section 170 says, a pledge requires the bailment of goods by owner, that is called pawner, to receiver, pawnee, as security. Only the owner typically holds the right to pledge, meaning a thief's pledge is invalid. As per the Indian Contract Act 1872 and related law, non-owners may validly place goods under specific conditions. So, this is the answer to the part 2 of this question. State the cases in which the goods can be placed by non-owners. So, as per Indian Contract Act 1872 and related law, non-owners may validly place goods under specific conditions. What are these conditions? Number 1. Mercantile agents. Under Section 178, a mercantile agent in possession of goods with the owner's consent can place them during the ordinary course of business, provided the pawnee acts in good faith. Voidable contract. Section 178A. Goods obtained under a voidable contract can be placed if the contract has not been rescinded at the time of the pledge. Limited interest. Section 179. A person with a limited interest in goods, that is, a bailee, can place them to the extent of that interest. Joint owner. A joint owner in possession with the consent of co-owners can create a valid pledge. So these are the specific conditions under which non-owners can pledge goods. Now essential conditions. For these pledges to be valid, the pawnee must act in good faith without notice of the pawner's lack of authority, and the non-owner must hold lawful possession. This is the answer for question above. Now question number 4. Explain the doctrine of caveat emptor. State its exceptions. The answer will be, caveat emptor is a Latin maxim meaning let the buyer be aware. Let the buyer be aware. जो खरीद रहा वो जाने. Beware. It is a fundamental principle of contract law codified in section 16 of the Sale of Goods Act 1930, stating that the buyer holds the responsibility to inspect goods and ensure their quality, suitability before purchase. It is the duty of the buyer to inspect goods and ensure their quality, suitability before purchase. If the buyer fails to do so, they cannot hold the seller liable for defects. Exception to caveat emptor. The rule of buyer beware does not apply in the following situation where the owner shifts to the seller. Responsibility goes to the seller. When fitness for buyer's purpose. When the buyer informs the seller of the specific purpose of the goods, relies on seller's skill judgment, and the seller deals in those goods, the good must be fit for that purpose. So, fitness for buyer's purpose. Sale under patent or trade name. If the buyer purchases an item under its patent or brand name, the seller is not liable for its quality, but If the item is not fit for its general purpose, the exception may apply. Merchantable quality. When goods are bought by subscription from a seller who deals in such goods, there is an implied condition that goods are of merchantable quality, fit for general use, unless the buyer examined them and missed a patent defect. Usage of trade. An implied condition or warranty as to quality or fitness may be annexed by the custom or usage of a specific trade. Consent by fraud or misrepresentation. If the seller obtained the buyer's consent through fraud, misrepresentation, or conceals a latent defect that cannot be discovered by ordinary inspection, the seller is liable. Now, sale by sample. In a sale by sample, the goods must correspond with the sample in quality and the buyer must have a reasonable opportunity to compare them. Sell by description. If the goods are bought by description, they must correspond with that description. These exceptions have gained strength through modern consumer protection laws, which increasingly favor caveat emptor. Let the seller be aware to protect buyers from defective products. So, this is all about question number 4. Now coming to question number 5. On which grounds is surety discharged from his liabilities? Comment. So these are the grounds. The discharge of a surety liability can be categorized into 3 main heads. Number 1, discharge by revocation. Discharge by revocation. Notice of revocation, which comes under section 130. A continuing guarantee can be revoked by the surety from future transaction at any time via notice to the creditor. Death of surety. Section 131. The death of the surety operates as a revocation of a continuing guarantee. Means guarantee is over regarding future transaction when there is death of surety. Novation, section 62. When a new contract is substituted for an old one. When a new contract is substituted for an old one, either between the same party or different ones, the old contract is discharged. And second is discharge by conduct of the creditor. Conduct of the creditor. Conduct of the creditor. The surety is released if the creditor alters contract terms without consent. The surety is released if the creditor alters contract terms without consent. Section 133. Discharges the debtor. Section 134. Or grants time to the debtor without consent. Section 135. Additionally, actions that impair the surety's remedy. Section 139. Or the unauthorized loss of security. Section 141. Discharge the liability. Third is discharge by invalidation of contract. A guarantee is void if obtained through misrepresentation, which comes under section 142, or concealment of material facts, section 143. Furthermore, a conditional guarantee is not binding if a required co-surety fails to join, section 144. So this is the answer on which grounds is surety discharged from his liabilities. So friends, this is all about the contract law 2 questions and answers. These questions are very important and you must remember these questions when you go for exam. Thanks for watching this video.